The next case is State versus City of Iowa with Jackson. Each party will have 15 minutes to present an argument. You can only reserve up to 5 minutes for rebuttal. Counsel, how long would you like to reserve for rebuttal?
You're on 3 minutes.
3 minutes, okay. I will be keeping track up here. I will try to let you know when you have about a minute left in your time.
Okay.
The arguments are being recorded. As you know, when you please come up to the podium, please introduce yourself. Please make sure you stay behind the podium. Please speak in a clear and loud voice so the recording can pick you up. Please try not to move from behind the podium or the video will do. You should not use the name of any child or minor or any victims in this case. Please use initials or refer to them as a child or a victim or some other designation. Please read your briefs and are ready to proceed whenever you can.
Good morning, Your Honors. May it please the Court, Lindsay Poprocki, on behalf of the appellant, State of Ohio. After declaring a mistrial in this case, the trial court went on to dismiss the indictment with prejudice. The trial court's decision to do so rested on the premise that an already declared unavailable witness under the forfeiture by wrongdoing exception to the hearsay rule became available to testify when her physical location became known to the state during the trial. The state submits that the dismissal with prejudice was error and must be reversed based on the assertion of 2 assignments of error.
Counsel, I hate to interrupt you so early, but I just want to make sure that we're clear that the appeal is about the dismissal with prejudice. It's not really about the mistrial.
That's correct.
Declaration of a mistrial.
That's correct. The appeal is solely related to the dismissal with prejudice. That's correct. It's solely confined to that. And the first assignment of error is that the trial court abused its discretion when it employed Criminal 48B to dismiss the indictment with prejudice absent certain required findings. Here, Criminal 48B does not explicitly provide for a dismissal with prejudice. And because the rule does not expressly provide for such a dismissal, case law has developed. And the Ohio Supreme Court has held that a dismissal with prejudice may be entered only where there is a deprivation of a defendant's constitutional or statutory right, the violation of which would, in and of itself, bar further prosecution. And this is where the trial court went astray in this case. Here, in dismissing the indictment with prejudice, the trial court did not find or make any specific finding that Stethon Jackson was denied a constitutional or statutory right that a violation of which would in and of itself bar further prosecution. Instead, the trial court provided reasons to support its declaration of a mistrial. Jackson has maintained that the trial court satisfied Criminal 48 when it stated its findings of fact and reasons for the dismissal orally on the record. He submits that the findings were reasonable based on certain concerns about how the state handled the prosecution, and that those concerns were grounded in his constitutional rights. But Jackson's argument misses the mark. Even if the factors cited by the trial court implicate his constitutional right to confront his accuser, the trial court's entry fails to suggest, much less actually find, that further prosecution in this case would be barred. In fact, when the trial court stated its reasons for the dismissal on the record, orally on the record, the state raised issue and noted that while the trial court had stated its reasons regarding the actions the state may have taken to support a mistrial, it did not find why a retrial would be barred. And in this type of instance, the Ohio Supreme Court has recognized that even if an offender's constitutional rights are implicated by the reason for the underlying dismissal, so long as the state can re-indict that offender and prosecution would not be statutorily or constitutionally barred, the dismissal should be without prejudice. For the sake of this appeal, Jackson is confined to the trial court's actual findings that were stated on the record and in its dismissal entry, not what he wishes the court would have found. To that end, the state properly cited and relied on State v. Payne, an 8th District Court of Appeals case that recently held that Confrontation Clause violation cannot be the basis for a Criminal 48. In Payne, like here, the victim did not appear on the day of trial, and the 8th District held that a Confrontation Clause violation cannot be the basis for a dismissal with prejudice under Criminal 48. That is because a constitutional right to confront one's accuser does not preclude further prosecution. The 8th District's reasoning is critical here and equally applies. It stated that any rights guaranteed under the Sixth Amendment concern admissibility of evidence, and therefore the evidence would be excluded at trial, and it does not preclude the state from proceeding with a future prosecution. And Jackson has claimed that Payne is inapplicable here and insisted that his constitutional right to confront his accuser was violated, but he still misses the point of the Ohio Supreme Court's precedent that further prosecution must be barred. Here, Jackson can be re-indicted because the statements of the victim are admissible regardless of her availability under other hearsay exceptions. Statements can be admissible under multiple different rules, and the state sought admission of her statements under other rules of other hearsay exceptions, including excited utterance and statements made to medical personnel. And the state's second assignment of error, we submit that the trial court erred when it dismissed the indictment with prejudice because the state did not engage in conduct which intentionally goaded the defense into requesting a mistrial. And generally, when a court grants a criminal defendant's request for a mistrial, the double jeopardy clause does not bar a retrial. A narrow exception to this rule does apply when the defendant's request is prompted or instigated by prosecutor misconduct designed to goad the defense into requesting mistrial. But in its entry dismissing the indictment against Jackson, the trial court focused almost primarily on the conduct of the state and the behavior of the state, and cited several factors to support its conclusion. However, even if the trial court concluded the result of the mistrial was due to actions of the state, those actions are still not a basis to preclude a retrial, because misconduct or conduct by the state itself is not sufficient to overcome the exception to the double jeopardy clause rule. Instead, the conduct must be intentionally calculated to cause or invite a mistrial. Therefore, only prosecutorial misconduct accompanied by prosecutorial intent will bar retrial. Here, the state asserts that the trial court's finding that a mistrial was a result of actions by the state does not equate to a finding of prosecutorial intent, and the trial court actually made a finding that there was not intention to be attributed to the state in its entry. The best evidence of these court's findings are in its entry. And finally, rather than seeking to invite a mistrial or go the defense into moving for a mistrial, the state vehemently opposed a mistrial. Ultimately, the dismissal of the indictment with prejudice in this case was inappropriate and improper. Based on those reasons, we would ask this court to reverse and remand.
Good morning, Mayor. On behalf of Mr. Jackson, Giovanna Bremke, good morning. Before I begin, I want to start with some preliminary objections that I outlined in my brief. Number one, I previously asked this court to dismiss this appeal, and I would renew that motion to dismiss. I'd also ask that the review is limited to the substantive legal issues, and for that position, I cite McElroy, which is a case recently in this court, in which the court decided to only review the substantive legal issues and not not disturb the finding of the case. I would also ask at the appeal, and I think the state conceded to this upon asking Judge Stethon, but that the review is limited to the dismissal with prejudice and not disturb the mistrial, because that mistrial was not appealed timely and is actually not before the court at all. And lastly, as far as preliminary objections go, the state has talked a lot in their brief and today about about double jeopardy attaching when the state goads the defendant in asking for a mistrial. However, there's actually two parts to that. State versus Glover says that double jeopardy attaches in two scenarios. Number one, the goading, that's basically the assignment of error number 2 here. And and secondly, if the court abuses their discretion in declaring a mistrial sua sponte. This mistrial was declared sua sponte, although the defendant asked for a mistrial. If you read the entries, it's very clear that the court declared it sua sponte. In fact, it explicitly states that in the entries. And the reason I point this out is even if you agree with the state and their first assignment of error explicitly said the court abused the discretion, you can't change the outcome of the case. So pursuant to Glover, and that's an Ohio Supreme Court case, because jeopardy attaches at that point. So even if you agree with the state on count 1, you don't need to get to count 2 with the goading, and I'm not suggesting that you should, but regardless, the outcome should not change. As to the assignments of error, I will point out that the case law that I cite indicates that the court has great deference in making these decisions. That's very clear. Again, the standard is an abuse of discretion. I think we agree on that. That's what the state's arguing, and that's what I've said is the standard. But again, going back to the Glover case, that means that the result cannot be disturbed. The state also makes an argument that the findings, in fact, their assignment of error, the whole assignment of error on count 1, is that the court should have made constitutional findings in order to dismiss the case, and that those constitutional findings are not in the entry. However, they're sort of combining here criminal rule 48B and this 23CA case, which is later cited to by State versus Stethon in the 9th District, which basically says that the double jeopardy attaches if there's a constitutional argument here. But it doesn't say, Criminal Rule 48 says that those findings need to be on the record, but there's nothing that combines those two, saying under Criminal 48B, there needs to be findings, which there were, very extensive findings, on the record and also in an entry. There's no case law, nothing that would combine those two, saying the constitutional arguments need to be in the record and in the entry. Regardless, they were. In fact, the state contends that they don't know what the constitutional finding or what the constitutional argument was. However, they went through such great lengths at the trial court level to talk about the confrontation clause that they even attached Facebook posts from the defense attorney talking about how the confrontation clause was violated. So it's very clear that they knew that it was the confrontation clause, which is a constitutional argument, that they were asking for a finding on. Now,
that's your position here, that the confrontational clause was what is implicated in this case.
Right, and you're probably asking me about the Payne case from the 8th District.
Well, you're not arguing any of the controversy, because the judge doesn't make a specific finding. I read it, the confrontational clause was violated. She talked about the things that happened.
Right.
Is there another constitutional right you think is implicated by this behavior by the state?
I think maybe the confrontation clause, I would agree with you, but I don't think that they need to be in the findings.
I'm not saying they have to, but I guess looking back at it, what was argued and everything else, it seems to me it's a confrontational clause.
Correct. And I understand that the states argue the Payne case. Number 1, it's an 8th District case. It's not binding on this court. Number 2, although they cite sort of the finding in that case, it's a very different case. In that case, the victim failed to appear for trial, and they never began trial. They just said, hey, can we get the victim here? And the judge got frustrated that the victim wasn't appearing and dismissed it with prejudice. Here, they didn't begin trial in that case, and they didn't begin testimony, and in this case, they gave a day and a half to 2 days worth of hearsay evidence. So it's a very different case based on representations by the state that the victim was unavailable. It's a very different case than Payne. And I outlined that extensively in my brief. And I would also point you to the Dunn case, in which that court said, hey, they upheld a trial court that didn't dismiss with prejudice, but they relied on 3 factors. And those factors, while they didn't apply in the Dunn case, do apply in this case for dismissal with prejudice. And that is, number 1, the integrities of the proceedings were preserved. Here, and I made an extensive argument, they weren't preserved, because now you have a victim who's been, locked up, been told basically you don't need to appear and these statements are going to come in. So in the future, she's never going to appear and never and testify truthfully. So the proceedings and the integrity of those proceedings are completely out the window. Number 2, the actions were discovered, whether the actions were discovered in trial or during trial. In the Dunn case, it's different. They discovered it prior to the start of trial. This was in the middle of trial, 2 days into trial. Although the state knew prior to any testimony that the witness was available and available for the court to question, that was not brought forward until 2 days into trial by the defense attorney. Lastly, whether the investigation into it resolved quickly. Again, in this case, it was 2 days before it was discovered by the court. And going to assignment of error number 2 quickly, I think that it's important to note, and I've sort of alluded to this and the state's talked about it, that the state didn't ask for a capias. The court had to prompt the state to ask for a capias, and then the state immediately asked for the capias to be withdrawn when when the victim's sitting in a jail in a different county, instead of asking for her to be transported. And the trial court makes an issue with this in their entry, saying, hey, we could have brought her here. All this testimony about her being unavailable was based on outside sources because she didn't appear. The state relies on this Ross case, which Ross has absolutely no holding by this court. States repeatedly in other cases relied on the Ross case, and it sets a terrible precedent because actually this court decided Ross was guilty regardless, and they didn't even get to the forfeiture by wrongdoing issue. But the state has used that case to support a position that we don't need victims and we can just bring in, the hearsay testimony regardless. And the issue that the court takes with that is, hey, in Ross, the victim appeared and invoked her Fifth Amendment right. Here, the victim doesn't appear at all. So we're just assuming that she's unavailable based on what these other people said. But the minute she becomes physically available in a different jail, she could be ordered transported, and the court and the attorneys could question her on her unavailability. And that didn't happen here. That goes to the goading, the fact that the state knew that she was available for transport, available to the attorneys, available to the court, and didn't allow for that transport. Until, again, 2 days into hearsay testimony, I cite and also the state essentially proves the goading in their brief when they say, hey, she was no longer a material witness. Yes, because that's what they said. They said, we don't need her over here. We withdraw our KPS. She's no longer a material witness because we already have 2 days of hearsay evidence in. It wouldn't otherwise be in if she was available. And so she's no longer a material witness. We don't even need her here. We don't even need her statements. So again, that proves the goading in and of itself. The Madison case I cite, in that case, the court agreed with dismissal with prejudice, and in that case, the case was going south. This is a direct quote from the case. The state's case was going south, and in that case, the prosecutor elicited a question that wouldn't otherwise be admissible about the defendant being a drug dealer. The reason I point out to you this, because the court's entry indicates that the state, this appears to be an attempt to present a case with an uncooperative witness but get those statements in, which is not permissible. And again, I would indicate to you that that's a similar case, because, we know that if a state's case does not have that witness, and I will point out to you, because I know this is something that you've made an issue with in the past, these hearsay statements wouldn't have come in otherwise. They weren't arguing that they come in under all of these other exceptions that they talk about. They didn't make those arguments before the court, and there was no other witnesses. Sometimes in these cases that we have, there's somebody else who could testify to this effect, that were there. These are two people. These statements would have only come in through the use of this witness, and she wasn't there. Any questions?
Is there nothing in the record that's gonna reflect any discussion about any of these other potential ways that the information could have come in?
I believe it was raised by the state after all of this, after the mistrial. But the court, I believe, addresses those and says, hey, you weren't asking for this to come in under excited utterance or medical records. You were asking for this to come in under forfeiture, and that's how it came in, forfeiture by wrongdoing. That's how it came in, not under these other exceptions. So the court, I do believe, addresses that and rejects it because it wasn't raised until after the mistrial. Any other questions? Okay, thank you.
Thank you. You have your full 3 minutes for rebuttal.
Okay, thank you, Your Honor. I would like to initially respond to the preliminary objections that counsel has raised. And first note, as I did in my reply brief, that the assertion that counsel filed a motion to dismiss this appeal is completely inaccurate. Jackson filed a motion for an order to limit this court's review, but the fact that she's asserting that she filed a motion to dismiss this appeal is inaccurate. The request was to limit this court's review to substantive law rulings only and to the mistrial itself, and not to the mistrial, to the dismissal of the case, and not to the mistrial. The basis for that request was on this court's ruling in State v. McElroy, but that case is inapplicable here. The court determined in McElroy that the state could not appeal of the trial court's judgment of acquittal against the defendant because double jeopardy principles barred her pretrial. That's not the situation here. This is not an appeal from a judgment of acquittal. Simply put, this is an appeal from the trial court's dismissal entry with prejudice. The trial court has entered a judgment dismissing this matter with prejudice, and it has not resolved the matter on the merits. And Jackson also insists that this court should limit its review to whether the dismissal of this case with prejudice was proper and assume regularity with regard to the mistrial. And the state agrees. The trial court did grant a mistrial on its own motion, and the state did oppose the granting of the mistrial, but the state did not appeal the declaration of the mistrial. The state's appeal is that the trial court dismissed the case with prejudice. And his citations to cite State v. Glover about the abuse of discretion regarding the granting of a mistrial, they're also inapplicable here. He did not appeal the trial court's granting of a mistrial for an abuse of discretion. And that is also a narrow exception to the double jeopardy principle that dismissals with prejudice can be an exception to the double jeopardy principle regarding mistrials, but that's not applicable here. The last question regarding whether the prosecutor moved for admission of the hearsay statements under other grounds, that's also an inaccurate representation of the record. After the court granted the motion for forfeiture by wrongdoing, the prosecutor specifically stated that the state would be presenting, possibly moving for the statements to be permitted under other exceptions, including excited utterances and statements to medical personnel. At that point, the trial court advised defense counsel that it should object to any statements that were admitted on multiple grounds to preserve the record. So that statement is just inaccurate. And part of the ruling at the end of the dismissal with prejudice was that those statements could not have come in under other exceptions, but the state has argued against that because that's one of the reasons that retrial would not be barred in this instance.
I know your time is up for rebuttal if you briefly conclude.
Okay. The state would just ask that this matter be reversed and remanded for dismissal.
Thank you.
Thank you.
The court will take the matter under advisement, will issue a decision in due course. That decision will be mailed to you by the clerk of court when it is released, and also will be available on the Supreme Court website. I thank you both for your presentation.